Hi everyone, good morning. Like to welcome all of you to our ongoing training series here at the ARC New York. We're thrilled today to have Laura Monti from the Justice Center, who's the Director of Surrogate Decision Making, here with us today, and we'll review surrogate decision making, the program that the Justice Center runs. I do ask that if you have any questions, you please enter them into the question box on the GoToWebinar dialog screen. We will stop periodically during the webinar to review the questions. And I think Laura will also provide contact information in the presentation should there be additional questions that you have. So without further ado, I'll turn it over to Laura.
Okay, thank you, Eric. This is Laura Monti, Director of the Surrogate Decision Making Committee Program. It's a pleasure to be here today to talk about surrogate decision making. Today, I'm going to be providing just a high-level overview of surrogate decision making, what it is that we do, how we operate, what are the regulations we operate under, what are the parameters, so to speak, who do we serve, and just an overview of today's, okay. So for the topics we're going to be covering today, it's surrogate decision-making history and background. Why was it necessary to, or what was the goal of initiating an SDMC program? The eligibility, jurisdiction, how do we determine if someone meets the criteria to be eligible for surrogate decision-making? Our major medical forms, how do you access those forms? What are we really looking for when you fill out the forms? We're going to talk a little bit about the hearing process, what to expect when you go to a hearing, how to provide testimony, the types of questions that you might be receiving if you're providing, if you're there as a provider. And also we'll talk about the Healthcare Decisions Act, the end-of-life process, and there's a lot of questions. There's also a lot of confusion that people have about the MOLST process. When the MOLST is completed after an SDMC hearing, it has to be completed after the hearing. So there are some guidelines. If you have questions, I always encourage people, if you're going through the SDMC process, always feel free to reach out to us at any point, even after the hearing, if you need assistance completing the MOLST or you have questions about that. So to talk about surrogate decision-making history, and just next slide, we're going to talk about why was it necessary and what really prompted the development of surrogate decision-making. Prior to surrogate decision-making back in prior to 86, when the law was, or when it was first proposed as a pilot program, there were statewide public hearings that were done in response to some of the conditions that people were found in Willowbrook, and there were concerns about the care and treatment of people with disabilities. So at the statewide public hearings, what we found is that there were untimely decisions offered through the court process for informed consent. At that time, the only way for someone without a guardian or a potential surrogate to make their decision, a family member or someone, at that time, the only way to obtain informed consent would be to go through the court, and it was costly. It was cumbersome. There were many times that people were waiting, sometimes a year, for informed consent for general anesthesia to obtain dental care, and our cases were often bumped from the docket. So there were a lot of concerns. Sometimes there were agencies that circumvented the process when they could, if they had someone that was maybe on the bubble of providing their own consent, but maybe didn't really have the capacity. There were also physicians who were likely to invoke the emergency exception to avoid the need for informed consent. So these were all things that really violated the rights of the individuals to have someone looking at the risks and benefits to really make an informed decision as to whether this was in their best interest. So at that point, the legislature and the governor, Governor Cuomo, Mario Cuomo, they proposed that there would be some type of legislation, and we can actually.
Sure.
Yep. So they proposed an alternative to the court system, because the delays in informed consent were often attributed to the court process itself and some of those barriers. So SDMC was proposed as a 10-county pilot program, which was made permanent in 1988. It was established by Mental Hygiene Law, Article 80, and Regulations, Part 710. And it started initially in 10 counties, operated through the Commission on Quality of Care, expanded statewide in 2001. We now operate in all 62 counties and approximately 1,200 cases per year, with about 10% of those cases being end-of-life cases. And that is actually something I just wanted to point out, that has steadily increased, which I think in part is due to the quality of care that people are providing. Our folks are living longer than they used to. And so we do receive probably 10%, but every year that percentage actually goes up. And for SDMC, we're authorized to make decisions only if a preferred surrogate is unavailable, unable, or unwilling, and the person lacks the capacity to make the decision themselves. So some of the benefits: we are cost-free to all providers, everyone involved in the process. We operate with volunteers that serve as panel members. We include the individual. We always have the individual present at the hearing, unless there's a medical reason that they are not able to be in attendance. So that might be if they're in the hospital. Very often what we'll do is we'll include the individual if they're in the hospital by having a panel member visit the patient. Mental Hygiene Legal Services will also visit the patient. And we would hold the hearing there at the hospital just for convenience too. There's also, we provide timely access to health care. The turnaround time for a case is usually within 14 days between the time that we receive the case packet and process that to the date of the hearing. So our goal is to provide that within 14 days, but it's also possible to have that in an expedited manner. So in those cases, if the physician feels that the healthcare need is urgent, but doesn't rise to the level of an emergency, we can actually sometimes receive the paperwork and hold the hearing within 5 days, sometimes even the same day, depending upon the situation. And those are special circumstances, but I just wanted to make you aware of that if you have a case that really needs to be heard as soon as possible, talk to us. We'll walk you through the process. We will do what we can on our end to expedite it and work with you to make the process go smoothly. We also provide due process rights. Everyone receives notice. All interested parties receive notice of the hearing, including the individual and any potential surrogates. So SDMC, surrogate decision making, is really about informed consent. So when we go to the doctors and we are looking for informed consent, what we're looking for is, the physician is required to provide a full explanation of the proposed procedure, information about the medical condition that requires the procedure or the treatment, the risks, the benefits, any alternative procedures that we could consider that may be less invasive or less time consuming, the level of discomfort, the effect on functioning, what could go wrong, and the individual needs to have the freedom to withdraw their consent at any time. So these are aspects of informed consent. These are also things that we require at the hearing, and this is what our hearing process is actually covering. So Eligibility and jurisdiction. How do we determine how someone is eligible? So we begin with what type of service recipient they are, and the eligibility will differ slightly between someone who's eligible because of OPWDD or because of their history as a service recipient through OMH. For the purposes of today's process, I'm going to focus mainly on OPWDD. So if someone is or has been a service recipient through OPWDD or an agency under the auspice of OPWDD, they would qualify for surrogate decision making, and that includes even a residential placement. It includes whether they've had service coordination, waiver services, and they don't have to be a current service recipient. So that covers the folks that maybe age out of a placement in a residence and maybe need more skilled nursing placement. So we do provide SDMC even for those folks that no longer reside in an OPWDD facility or under the auspices. So folks that are transferred to nursing homes, they would be able to, they would be eligible for SDMC. We also would have to have reason to believe that the individual lacks the capacity to consent or to refuse medical treatment. So we have to have, part of our process, one of our forms is actually a capacity assessment where we have a licensed psychologist or psychiatrist actually do a capacity evaluation on the individual to determine whether they have the capacity to consent for that procedure. The capacity assessment is relevant only to we're always looking at capacity each time the person comes to us. So just because someone has a significant disability or even a mild intellectual disability, it doesn't mean that they're always going to lack capacity for the same procedure. And I'll talk a little bit more about that later, but anyhow, we are always looking at capacity. We also have to have a reason to believe that the person does not have a legally authorized, willing, and available surrogate. So there are folks that do come to SDMC that may have an actively involved family member, but for whatever reason, they're not available and willing. So we cover that with our due process notifications, but and we attempt to include the family whenever possible or the actual surrogate appointed person. But surrogate decision making is an option for everyone. We are one option. The court of law still remains another option. So the major medical treatments that are included, and these are covered in our statute and also in our regulations, we're looking at treatments with a significant risk. So that might be even a diagnostic procedure such as a colonoscopy where there's a risk of perforation. It could also be MRI because a lot of physicians consider that a significant risk because sometimes when people are transferred between residences, they might not always know if they've had an implant or some type of metal or a pin placement. So it is important that somebody is looking at the risks and benefits and any alternatives with regard to that person's right to informed consent. We also cover major medical treatments we cover treatments or procedures that involve the use of anesthesia, whether it's monitored, IV sedation, or general anesthesia. So these might be things that are considered routine care, such as dental procedures, or it could also be GYN examinations or sometimes diagnostic testing. But the reason they're coming to us is not for consent for a GYN exam. That's considered routine care. It's because maybe there will be a IV sedation used to facilitate the person's cooperation. So those are cases that could come to us. And if there's any significant invasion in bodily integrity, which requires an incision or produces pain or any temporary disability or debilitation, those are things from anything from your surgeries, your scrape biopsies, even from a dermatologist. Sometimes they go a little bit deeper and there's a risk of a suture. Sometimes, it could be something where it could be a kidney transplant, open heart surgery, it could be anything. So that covers, those major medical treatments are included, and there's a range associated with that. We also we cover chemotherapy and of course hospice treatment, but any treatment or procedure for which informed consent is required or requested by the physician. So sometimes there might be questions. We just recently had a case where someone was going to be receiving corticosteroid injections in the knee to treat some type of arthritic condition in the knee that was painful. And the risks and benefits were considered well known, but the physician wanted informed consent. So in those cases, if the physician wants informed consent, that they feel that maybe there's something related to this person's physical condition or their medical history. It could also be because of a medication that they're taking. I've had cases before that have come to us for routine dental, but we took the case because the dentist didn't want to proceed with a tooth extraction under local anesthesia because without informed consent, because the person was on Fosamax, and there's a risk of jaw necrosis associated with that. So those are situations that, if you have a case that if you call SDMC and somebody there says, no, that's considered routine care, we don't cover that, just be aware that if the physician feels there is a reason, please call us back and discuss it, and we'll walk you through that process, okay? So there's also procedures that we are explicitly prohibited from covering, and that would be routine medical care. So if somebody is compliant with their dental care, with their examinations, labs, anything like that, then they don't need to come to SDMC. That's routine medical care. We also do not provide consent for psychotropic medication. There's a different process to go through for that. We don't provide consent for emergency treatment. There are times that we'll receive a call from a hospital and they'll say that they have a situation where the person is in a very serious condition. I'll give you an example. We had someone who fell about a year ago and needed a pin placement in her knee, and the risk of not providing the procedure and the surgical intervention right away was that the kneecap would fuse, and it would fuse improperly. So there was a risk to her mobility associated with that. And what we did in those cases, what we can do is give us a call if the physician really wants something from SDMC to explain how soon we could provide a hearing. Even if we receive perfect paperwork, sometimes we can't guarantee that our contractor in your region will be able to schedule a hearing within 48 hours. So we have access to the calendar to look at everyone in real time, where they are, what they're doing, what's on the calendar in each region for coordinators. So we can pretty much tell you exactly when or if we might be able to schedule a hearing, or how soon we could. And in those situations, maybe it is better to proceed as if that's an emergency, and we can provide some type of written documentation for the physician for them to cover themselves and at least have something on the record that they did attempt to obtain informed consent, but due to the delay, there was too great a risk to wait for informed consent. We also do not provide consent for dental care performed under local anesthesia. The caveat here, though, is there are times that someone may be having dental care performed or an extraction under local anesthesia, but if there's a risk of sutures and incision, bone fragments, if that's added to the consent, that's something that we will cover. So We do not cover electroconvulsive therapy, sterilization, termination of pregnancy, and we also do not cover withdrawal of life-sustaining treatment for non-qualifying individuals. So that would be anyone without a diagnosis, any other service recipient that would otherwise be qualified for surrogate decision-making, but does not meet the criteria for having a developmental or an intellectual disability. So the jurisdiction for withdrawal and withholding of life-sustaining treatment is really restricted to individuals who are diagnosed with an intellectual or developmental disability. And this is what we're going to talk about a little bit later when we discuss the Healthcare Decisions Act. We were granted the jurisdiction through an amendment to the Healthcare Decisions Act, which started in 2009, to provide end-of-life treatment decisions, including DNR, DNI, for people with developmental or intellectual disabilities. The person does not need to have ever received services from OPWDD. It's just the diagnosis of intellectual or developmental disability that qualifies them. So I'm going to talk a little bit about some of the definitions. These are some of the words that we tend to throw around a lot when we're talking about surrogate decision making, just so that you can understand who these, the definitions and the specific references that we're using in our terminology. So when we talk about the declarant, that is the person that is identified on the major medical form, the 200, or on the end of life form, the 300 form, who's basically bringing the declaration forth to surrogate decision making on behalf of the individual. It couldn't be a provider of health services. There are times that it's done by the residential manager. It could be done very often it's done by the Medicaid service coordinator. It could also be the residential director or manager of the residence where the individual lives, or the residential nurse. It could be anyone. It could even be a relative. But it should be somebody who is familiar with the individual, that knows their baseline abilities, what types of decisions do they make on a regular basis, and what is their family status? Who visits them on a regular basis? Is there any family member that's actively involved who previously provided consent for this individual? And they should also have some sense of this person's medical needs. Why is this treatment being proposed? Why is this in this person's best interest? And if they don't have that information, they should at least know where to find that information or who to obtain that information from, and make sure that that person is also available to provide testimony at the hearing. So when we're looking at major medical, we have 4 declaration forms. Oh, this is for end-of-life care decisions. Was there one before that? Okay, so there's 4 for end-of-life decisions. We'll go into this a little bit later, but this is the Declaration for End-of-Life Care Decisions, Form 300. The certification on capacity is the 310. Certification of medical need and supplemental medical information is 330B, or 330.
Go ahead, 3 to the 200s. Go ahead, 3 to the 200s. What was it? The 200s.
Oh, okay. So major medical.
Okay.
I'm sorry.
That's
I
okay.
apologize. There were some revisions done, so.
Let's take a brief pause and
Okay.
see if there's any questions. We're going to place everyone on mute just for a minute while we pull up the question. All right, so we have 3 questions, and I'll be the what do I be?
MC.
I'll be the MC. Question number 1: Can an authorized surrogate, such as a parent or guardian, still ask for the assistance of SDMC when they are not sure about a medical procedure for the person with IDD?
And hello, Erica, one of my favorite panel members. I'm actually, yes, anybody can, an authorized surrogate can, and there are times that we actually have had situations where NHLS contacts us, the providers contact us, and there might be someone who meets the criteria to be an authorized surrogate, but it might be a very complicated procedure. So what we often propose to the potential surrogate is, why don't you bring this to SDMC? And anybody can bring it to SDMC, and it doesn't mean that the surrogate loses their ability to participate or make the decision. It comes to SDMC, they participate in the hearing, they receive notice of the hearing, they see the paperwork, the declaration, the medical forms, and they can ask questions that very often, if it's a complicated proposed major medical treatment or an end-of-life decision, that might be something that the physician will actually be providing testimony during the hearing. So they can ask the physician any questions they want. They can also participate by phone if they're not local. We want to include the family as much as possible. There are times that we have had family members that are uncomfortable making the decision. They feel it's too much of a burden, the risk is too high. They might feel better putting it in the hands of surrogate decision making, but participating in the hearing to share what they feel is in their loved one's best interest. So in those situations, the win-win on this is actually that they retain the right to object to the decision. So if they're not in agreement with what surrogate decision making recommends or authorizes or grants consent for, they retain the right to object, and the decision ends. So,
okay. Question 2, I'll take this one. Will the presentation slides be available? I think that's okay to share.
mm-hmm.
And we're also recording today's session, and we'll send out a link within the next week or two so everyone can see the playback. Last question, a good one. So after July 1st, the care manager of the CCO will be part of the process in place of the MSC.
That's correct, and this is probably one more thing that we need to add to our form revisions. As anybody that has done anything with SDMC knows, our forms are constantly being revised. That's going to be forever, and I apologize for that. I will tell you though, the most recent forms are always going to be available on the website. If you need us to send them to you, we have PDF fillable forms that I'd be happy to send them to you. But yes, please, wherever you see MSC, you can put in the CCO, that anybody can be it doesn't have to, we use MSC just in general, but I think everybody knows it's the same process. All right, so major medical forms. Okay, so for the declaration packet, this includes the 4 forms that are submitted to SDMC. So there's 4 forms for major medical treatment decisions. It's the declaration, the capacity assessment, the medical certification, and then the supplemental medical information. 4 forms, as we just reviewed, for end-of-life care decisions. We have samples of these forms on the website. We also have as I mentioned, the PDF fillable links. These are the declarant completes the 200 form, the declaration. There's no reason that the declarant can't complete the supplemental medical information as well. But as I mentioned before, the capacity evaluation is done by someone who is either a licensed psychiatrist or licensed psychologist, and the medical has to be completed by a physician. So the medical certification is always completed by the physician. And that basically says how they want the consent to read. It talks about the physician answers the questions as to the risks and benefits and alternatives of the procedure, and why it's recommended, what would happen if the procedure wasn't provided for the individual. And the supplemental medical information is really a snapshot of the past year with any pertinent history on the patient. We're looking at any recent hospitalizations. We always want a copy of the annual physical. We want to know if there have been any diagnostic tests that might be relevant that we could obtain copies of for our panel members. So these are all things that go into the declaration packet. And again, these are the 4 forms that we talked about. You can go ahead.
Okay.
When we talk about a lack of ability, this is the way that SDMC and our statute defines the lack of capacity. So we don't actually call the person incapacitated, but we refer to having a lack of them as having a lack of capacity to make that particular medical decision. So if a person lacks the ability to consent or refuse for a medical treatment, it's because they can't understand the proposed major medical treatment. Maybe they can't demonstrate an understanding of the risks, benefits, and alternatives, or provide or articulate maybe their decision-making process, why they feel this is a good decision for them. And we try to really stress this with our panel members, that it's more than just saying whether they want the procedure or not. It's more than having them parrot back to you what they want, what the procedure is. It's really having them have an understanding and demonstrate the ability to discuss that rationally and to articulate what's going to happen, why is it recommended, and what are the risks and benefits. We also have, you're going to hear us talk about correspondence, and correspondence it's a unique type of person in this individual's life, who it might be somebody who is maybe not, they don't have the legal authority to make the decision, but these are going to be folks that work with the individual. Very often when we have SDMC cases, we'll have people come to us that have someone listed as a correspondent who actually was a former staff worker, someone that worked with them for years. Maybe the staff person has moved on to a different residence, or they've retired, but they've maintained contact with some of the folks because they had a good relationship with them. And this, very often, these are the folks that know this individual really well. They know their history, they know their family circumstances, they know who's involved in this person's life. They also know how this procedure is going to affect or be experienced by this individual. And that's really what we're looking at. We're looking at how is this going to be in the best interest of this particular individual. So a correspondent is someone who really has a genuine interest in promoting the individual's best interests, either in advocating for the procedure or an alternative. It's someone that has this personal relationship with the person, that understands them. It could also be someone who participates in their care and treatment. So that might actually be a sibling or a family member or someone who could be a surrogate who chooses not to be. So this is the situation that we have, where you have a family member that maybe they don't want to make the decision. We see this a lot where people may have had family members that made decisions for them for years. Sometimes it's a brother and his wife. I'll give you an example. We had a case recently where someone came to us, and it was the first time they had ever been to SDMC, and this individual was in her late 60s, and we said, well, who previously made decisions? And it was her brother. The brother had passed away, and the sister-in-law was still involved, but she had her own health issues. She didn't want to be responsible for being the contact, for always providing the consent and going to the medical appointments or talking with the physician. So at that point she said, I want to know, and I'd like to be notified when there are procedures that are recommended, but I don't want to make the decision. So a correspondent is going to always receive notice of the hearing. They'll receive a partial packet so that they're aware of what information or what procedure is being proposed, but they aren't obligated to, they aren't always obligated to attend the hearing or actually participate. It's just that it's somebody that has this interest in this individual and their well-being. So again, friend in the community. It could also, we also call family care providers. correspondence. They're entitled to some of the information. They do have an interest in this person's well-being, but they don't have the authority to make the decision. So this is going to look very familiar to everyone. Who has the ability to make the decision? OPWDD has a hierarchy that this should look very familiar. We begin with anyone who's lawfully empowered as a legal guardian. With those, there are different types of legal guardians, and this would be a legal guardian that has specific rights in the guardianship to make medical decisions. Or it could be someone who's been appointed as a healthcare proxy. There are special requirements for the healthcare proxy to be executed, and if that's indeed executed properly, MHLS is always available to review a healthcare proxy if you want some type of letter confirming that it's been reviewed and it is indeed adequately or executed properly. That's always a good idea. So we look at, does this person have an actively involved spouse, an actively involved parent, adult child, adult sibling, family member, and really the last resort is surrogate decision making. So these are the legally authorized surrogates. SDMC and also Consumer Advisory Board. SDMC does not become involved unless there is no one else. So that's the important thing to remember here. When we're looking at best interests, and this is really defined in our statute and in our regulations, we're really looking at promoting the personal well-being by the assessment of the risks, benefits, and alternatives of the proposed major medical treatment by taking into account how is this going to relieve this individual's suffering? What will be the impact on this person's quality of life? Will they have a restoration of functioning? Will they be able to see better after the cataract surgery? And what will that mean? You know, and for different people, there's a different different level, I guess, if you think on a continuum. For some people, having cataract surgery, if this is someone who enjoys watching television, interacting with peers, going bowling, being outside, being able to see and having their vision restored is going to be it's going to have a huge impact on their quality of life. If this is someone who prefers to be alone, maybe doesn't like a lot of stimulation, doesn't enjoy watching television, maybe even has some self-abusive behaviors, there's going to be some risks associated with the cataract surgery, especially if they have to tolerate eye drops or have to be restrained for several weeks in order to, you know, avoid injuring the sutures or disrupting the healing process. So you really have to think about, we ask our panel members to look at each case individually based on the best interest of that individual person with knowledge of that person's quality of life with and without treatment. And if there are any personal beliefs and values that are held by that individual, has that person ever expressed a desire not to have that treatment? And can they articulate that well? So we're going to talk about the hearing process. We have actually more information about the hearing process on our website. There's also a link to a mock hearing video, which provides information. It sort of narrates it through the process of the capacity evaluation, or the capacity section of the hearing, the surrogacy, the best interest, and then it'll give you an overview of the type of testimony that we're looking for, the types of questions you can anticipate. So I really encourage anybody that has questions about the process or has never participated in an SDMC hearing to at least watch the video and get a little bit more information that way. So when we look at the case review process, these are the steps that we follow. We start with the declaration is submitted. We receive approximately 1,200 declarations each year, and the declarations come by mail, fax, email. I have to say, if you ever fax anything, make sure that you call. I can't stress that enough. We have an e-fax that For some reason, sometimes providers send things and we only receive 3 pages of a 70-page or 50-page document. So always call us to confirm that it's been received, or you can also email us at sdmc@justicecenter.ny.gov. But the declaration is submitted, it's logged in and assigned to one of the nurse case review processors, and we have 3 nurse case processors that are assigned full-time to look at the cases. They look at the information in the declaration, they're looking at the supplemental information that was included. They're always going to reach out and call the declarant that submitted the paperwork. We're going to go through the declaration. We're also going to prepare you if this is the first time that you've ever submitted a declaration. We're going to prepare you for what to expect, how you're going to be contacted about the hearing, what to bring, what to expect. We also have some guidance documents on this too, and I'd be happy to share those with you as well. We're hoping to have those up on the website sometime over the summer. But if anybody has questions, feel free to always give us a call. We are always here to help. So SDMC processes the case. That usually takes probably 3 days. Sometimes we can turn it around within a matter of hours. It goes to the regional contract office. And the regional contract office, we have 6 regional offices. We have Long Island, we have Rockland County, Western New York, Central New York, Capital Taconic. We operate the Sunmount region through our office. We administer those hearings through our office in Schenectady. But the case is scanned, the declaration and all of the information, it's scanned, it goes to the regional contract coordinator. That's the person that's going to call you as the declarant to schedule the hearing. And as the declarant, you're really the point person with the team to make sure that anyone that is supposed to be there to provide testimony is aware of the hearing. We also provide notification and a copy of the packet to the residential nurse, to the residential manager, the house manager. And the hearing is held. We always ask that the declarant or the residential nurse brings a copy of the person's medical record. It could be the binder, whatever you have that has the most recent medical information, because there might be a question. Sometimes panel members have questions about a person's history, or they might see something in the declaration that they have questions about. So it's always important to have that information, because if you're not able to answer the question at the hearing, it might mean that the hearing is adjourned and there's a delay in this person getting their consent for the medical care until you have that information. So always do that. And the decision is generally issued, probably 5% of our cases, the decision, we don't issue a decision. So that might be a situation where there's more information that's required, and we'll reconvene by conference call at a later time to continue the hearing and once the additional information is obtained. But for the most part, 95% of the time a decision is issued. And not that we expect our panel members to rubber stamp anything, but for the most part, if we've done our due diligence and really tried to put the best case forward and prepare the providers for testimony and what to expect, most of the time the consent is granted. There are instances where sometimes a case is brought to SDMC, and we pretty much know that, in our discussion with the declarant, our conversation, that maybe they're not 100% sure that this is in this person's best interest, but they still want it to go before the panel, and that's okay too. It's okay to have it fully vetted before the panel. When we have a hearing, these are the participants that you're generally going to see. There's typically 12 people in the room. We always invite the individual. The individual must be there. If there's a reason that you believe the individual might not be able to participate in the hearing, even for 5 minutes, We have had some situations where, as you can imagine, this is an uncomfortable situation for folks. They're coming into a room, maybe in a place that's not familiar. It might be that there's people in a room that they have never seen before, and maybe their experience is that that's not a good thing. And sometimes it makes people fearful. We have had situations where people have acted out behaviorally. So we want to make sure that the individual is going to be as comfortable as possible. So if this is a person that maybe they go to a day program, maybe there's a place at the day program that is a great place to hold the hearing. If that's the case, let the SDMC coordinator know when they contact you to set up the hearing. We try to be as flexible as possible. For some individuals, they're more comfortable at home with their familiar staff around, where they can easily be brought into another room if they're having a difficult time with the tolerating the hearing and the new experience. We also want the declarant to be there and the residential nurse. The residential nurse is generally the star of the show because they really are the ones that carry the hearing with regard to the testimony. They need to be able to explain the medical procedure in terms that the panel can understand, to answer questions as to why it's proposed, the risks, benefits, and why this is in this person's best interest, and also to talk a little bit about what they know about this individual in terms of how do they recognize when this person is in pain, what is the aftercare plan. So the residential nurse really has a very important role to play in the hearing, but it's also important for the declarant, the Medicaid service coordinator, residential manager, anyone that's very familiar with this individual, to provide information about what is this person's daily life like, what kinds of decisions do they make on a daily basis, do they pick their own clothing, what was their reaction when the procedure was explained to them, and how will this benefit this person? And because these are the folks that really know this person better than anyone. So these are very important people to be present at the hearing. For panel members, we always have, we try to have 4. We can hold a hearing with 3, but our preference is always to have the 4 panel members. And there's 4 different roles for the panel members. We have an attorney, we have a medical professional, we have an advocate, and also someone who is a family member of a person with a disability. Any interested parties or correspondents are also invited they receive notification 5 days before the hearing, and Mental Hygiene Legal Services is there as the legal representative of the individual, and the local SDMC contract coordinator is there to administer the hearing. So they bring the paperwork, the hearing is recorded, and the audio is uploaded. So that's another thing I also wanted to mention. If there's ever anything that's a concern at a hearing, or you have questions about after a hearing, you can always give us a call. We can always review the audio of the hearing and kind of explain what happened or what they were looking for. So we're happy to do that. We want people to be comfortable participating in this process. So again, these are the volunteer panel members. We always have a licensed medical professional, and that could be, we have physicians, dentists, psychiatrists, occupational therapists, physical therapists, licensed clinical social workers. We also have a New York State licensed attorney, an advocate, and family member or former service recipient could also be on the panel. Now, the 3 decisions, there's a very distinct transition and a very distinct process as we go through the hearing. We're always going to, we begin with an opening statement, which basically reads the statutory requirements and the statutory jurisdiction into the record. And the reason for the hearing, all parties are introduced for the record at that time, and anyone providing testimony will be sworn in. we're always going to start with capacity, and we're looking at, does this person have the capacity to understand the risks, benefits, and alternatives to the medical procedure? And is there, once this is fully vetted, the capacity questions are always going to begin by being directed to the individual, and regardless of the person's presumed functioning. So we're always going to give that person an opportunity to demonstrate their capacity as much as they are able. There is a very distinct transition to legally authorized surrogate. The panel chairperson will move on to getting the information on the record as to whether there is a legally authorized, willing, and available surrogate who can make the decision. And then finally, we get to best interest. And best interest tends to be the longest part of the hearing. For some cases, and I will say probably 60% of our cases, possibly more, are really for colonoscopies for routine care such as that. But, and those are pretty predictable in terms of the types of questions that are going to be asked and all. But there might be other comorbid conditions that the person is experiencing or has as a diagnosis. So these are all things that get factored into best interest. And this is really where the providers, you really need to be able to talk about this person's history. How are they going to tolerate this procedure? How are you going to know when this person is in pain? How are they going to be medicated? What's the aftercare plan? Those are all things that can factor into the best interest testimony. So going back to capacity, when we look at the capacity assessment, every time a person comes to SDMC, there is a capacity assessment that's completed. And the capacity assessment is really looking at the person's ability to provide consent, or their own informed consent for that specific procedure. It does not generalize to anything else. It doesn't generalize, even if they're looking at the capacity of the person to provide consent for a colonoscopy in March, if the consent runs out and they come back to SDMC for a similar procedure, maybe another colonoscopy 10 months later, even though they've had the capacity assessment within the past year, if it's somebody that's pretty high functioning, we're still going to ask that you look at their capacity, that the capacity assessment is updated, even if it's for the same procedure, because sometimes the person obtains information just by the experience of having had the colonoscopy, and they can tell you more about it. Maybe they have learned something and have more knowledge about that. So we're really looking at, does this person have an understanding of the burden of treatment, appreciation of pain with and without treatment, understanding of the prognosis, and evaluation of treatment options. And these are really the things that we're looking at with best interest as well. So when we transition to the legally authorized surrogate, there are questions that are going to be directed to the individual or staff to verify that there is no authorized, available, and willing surrogate. So they might ask questions as to, looking at the declaration, we see that there is a correspondent or an advocate. Does this person have the ability to make the decision? And they'll just obtain that for the record. A lot of times they're asking very simple questions, but it's really to establish on the record that they've done their due diligence to rule out that there is any authorized, available, and willing surrogate. If there is a surrogate, and there are times that this happens, we've had situations where someone might be in the hospital and they have a healthcare proxy that's been appointed, or they've executed a healthcare proxy, but the healthcare agent himself or herself is out of the country or not available, and they need informed consent as soon as possible. So what we can do is we can actually still take the case. Maybe we will try to contact the surrogate, make them aware. We would find a way to get the information to them. But any potential surrogate receives a copy of the 5-day notice of hearing unless the case is expedited. We always notify parent, even if the person is in a if the parent is in a nursing home and maybe not able to make their own medical decisions, we're still going to reach out to anyone who has the potential to be a surrogate and provide them with due process notification, make sure that their right to make the decision is respected. We don't want to make the decision if there's someone else that's available. And there are situations where sometimes someone does respond to the notification and appear at the hearing or contact us when they receive the notification. And that's fine. Our process ends at that point. So the types of questions you're going to see in terms of best interest, the questions are really going to be directed to the residential nurse. Questions are addressed to the physician more likely. The only time that we're really going to require that a physician attend the hearing or participate in a hearing is going to be for an end-of-life hearing. And that's because there are specific criteria that we have to have on the record that can come only from the physician. But the nurse is basically the one who answers most of the questions with regard to best interest, and establishes that the proposed treatment plan is truly in the best interest of the individual. And this is done by, sharing information about any unique characteristics of the person, his or her medical needs, and how is the proposed treatment plan going to impact this person, their quality of life, their functioning, etc. And also, will the procedure restore this individual to a previous level of functioning or improve their current circumstances? So these are often questions that we're looking at with, the example I used before was about the cataract surgery. But it could also be a situation when we're looking at best interest. Sometimes we're looking at, it could be an individual who is has a chronic kidney condition and has reached the point where they're going to need dialysis. And so when we're looking at, do we provide consent for the dialysis and the fistula placement, etc., how is this person going to tolerate being restrained for 3 times a week for several hours at a time, and a rather unpleasant type of experience? So these are all things that really factor in. We're looking at this individual, every individual on a case-by-case basis. Every hearing is different, and it's really, we're looking to you as the providers to give us the information. So there's 6 possible hearing outcomes, and as I mentioned before, most of the time consent is issued, and that is issued on a Form 280A. It's a 2-page document, and it basically states who the declarant is, when the declaration was submitted, who provided the capacity assessment, who provided the medical assessment, what specifically is consent, what we're granting consent for, and also the time that the consent is issued. And there's various time periods it can be issued. Most of the time consent is issued. There are some instances where consent is denied. We try to encourage people that rather than, we have consent is denied or a no decision, those are 2 options that we try to have people, our panel members, really think about, because if consent is denied, it means that the procedure is not in this person's best interest. So that's one scenario. If it's a no decision, it might mean that there's the panel was split. It might be a 2-2 decision. We need 3 panel members to agree that it's in this person's best interest in order for consent to be granted. So in those situations where you have a no decision, there's a couple of remedies. We will always reach out and contact you if it's denied or if there's no decision. And we will also, try to sort out with you as to what the best course of action might be. Sometimes it might mean obtaining some additional information or a second opinion and bringing it back to a panel for a hearing. It might also mean getting new information and bringing it back to a different panel. Sometimes, I'll be honest, our panel members are human, and sometimes they may not be making a decision. You might not believe that they're making a decision that is in this person's best interest. And sometimes it does help to go to someone else that maybe would be open to, an unbiased and open presentation to reconsider. We also have had situations where this doesn't happen very often, but it has happened where a panel decides that the person has the capacity to make the decision. And in those instances, a 280C is issued, and you can actually bring that to the physician, and the physician will accept that as evidence that the person has been deemed to have capacity at that time. We could also find that the person lacks capacity but does have a surrogate. Does not happen very often. I can think of maybe 3 times in the past 5 years that that's happened, but it does happen sometimes. There's also an option for a conference call, and that's, by a conference call, what I mean is the panel might say, if we had information about the colonoscopy that this person had and the biopsy that was done 5 years ago, I think we would know whether it was in this person. We'd have a better sense, and we would be convinced as to whether this is in this person's best interest at this time. So if that's the case, then they'll do a conference call, and that means that the providers, MHLS, will call in, they'll share the information, they'll go through the information, and at that point they'll vote and issue a decision at that time. So our consent for major medical procedures, it's valid for 60 days. Now that's our default. It's always possible that you might ask for a 365-day consent. And in those cases, that's the longest we can do. And in those cases, those are things like if you're having a PEG tube placement and replacement, sometimes they do need to be replaced. So our panel will grant the consent for longer than 60 days, for 365 days, or for dialysis, something where a procedure might be repeated. We sometimes have people that are undergoing bladder treatment for bladder stones or tumor, and they want to repeatedly be able to go in and do a cystoscopy to monitor their response to treatment and identify any problems early. So those are also cases where the person might have a longer consent. The other thing to note with that is that it's not a one-time deal. That consent is valid for that time period. So if you have a consent for a cystoscopy for 60 days, you can use that consent for the cystoscopy, but if it has to be repeated, you don't need to come back to us for any permission to use that same consent. If the consent is still valid, you can use that. They can repeat the procedure as long as the consent is still valid. There's also no additional consents for anesthesia and or admission. So our consent, if you look on the second page, and I'd be happy to send people a copy, a sample that I use in training sometimes. There's a paragraph that talks about related procedures, and that's basically a clause that allows a physician to move forward with a related procedure if it's deemed necessary by the treatment that we provided consent for. So in these situations, if somebody is doing a colonoscopy and they see a polyp or a tumor that needs to be removed, they can go ahead and proceed with that because it's related and necessary. They don't, just because the polypectomy is not listed on the consent does not mean that they have to come back to SDMC. We want them to provide the medical care that this person needs according to the treatment and the assessment that was done. Okay, so
why don't we take a quick break and see if there's any questions?
Okay.
We'll be right back.
Okay, this is Laura Monti. I'm going to continue with a discussion of Healthcare Decisions Act. So, all right. Healthcare Decisions Act is, as people are familiar, it's an amendment to the guardianship law, the 1750B process. It applies to all surrogate decision makers for persons with intellectual or developmental disabilities. And this includes family members, guardians, and also SDMC. So I mention that because I often like to tell providers, please be sure that even if you have a family member that's authorized to make these decisions, please prepare them in advance that there is this 1750B process. Refer to the MOLS checklist. There are certain protections that are in place, but very often, I know myself, I've received calls from family members following their decision for an end-of-life care decision for their loved one, and it has to do with their frustration with the 1750D process. So SDMC didn't create that. That's part of the law, and there are good reasons for that to be in place. There are 2 exceptions, and we always try to vet this out when we receive a call from a hospital or a provider. Is there any chance that this person has a healthcare proxy or has executed a healthcare proxy? Or is this person being evaluated for possible brain death? And we ask that because these are the exceptions. If the person has executed a healthcare proxy, the healthcare proxy can make the end-of-life care decision outside the 1750B process if it is a brain death. And this is very often something that they're evaluating over time. So it's very often a 48 to 72 hour process, but we will ask if they have started, if there's something that looks like in the record that there might possibly be a brain death. So prior to the Healthcare Decisions Act, and Healthcare Decisions Act was really, it came about in 2002, basically in response to some pretty horrible, very sad cases, because at that point in New York State, there was no ability of a family member to withdraw or withhold life-sustaining treatment if the person didn't have a healthcare proxy or indicate in a capacitated manner not to be treated in such a way. So the law defaulted on the side of life that if the person had never, in a capacitated manner, expressed a desire not to be placed on a ventilator or on a feeding or receive a feeding tube, there was no way for a family member to interfere with that. So again, we have a hierarchy of decision makers. This is going to look very familiar, but it starts at the beginning, and this is the hierarchy that we're also looking at when we receive an end-of-life case to see if there are any of these folks who are better suited or better able to make the decision on behalf of this individual. So the main thing to know with the Healthcare Decisions Act is that there are special protections. And again, these special protections apply to everyone involved in the Healthcare Decisions Act process, every decision maker. So in each instance, there's going to be 2 capacity certifications. There's going to be 2 medical certifications that confirm that the person meets the medical criteria for the condition, and also that we document the burden of continuing the life-sustaining treatment. There's best interest considerations that are unique to the 1750B process. There's also special considerations of the unique nature of artificial nutrition and hydration and the burdens associated with that. There's a decision-making standard, and there's also a requirement for proper notifications to all interested parties. Primarily, the notifications that we are concerned about are to MHLS and to the executive director or the state operating office through OPWDD. All right, so we're going to talk a little bit about the forms. We have the Declaration for End-of-Life Care. This is the 300 form. These are the 4 forms that are going to be submitted together from the declarant. Sometimes it comes from the hospital, but it helps if the hospital and the residential providers are working together. So in all honesty, if I get a phone call late on a Tuesday afternoon that there's a case coming from a hospital, I'm going to look up in our database and I'm going to see, has that person come to us before? Who are the residential providers? And I'm going to send them an email or try to call them to say, hey, contact me. I want to work with you to get this information together as soon as possible. Very often the providers have been trying to reach out and work with someone, and it makes the process go so much smoother. So if you know that there's a declaration that's going to be submitted by the hospital, feel free to give us a call and I will connect you. We'll make sure that you're in touch with the person at SDMC that's processing the case so that we can expedite this process and meet this person's needs. So the 2 capacity certifications, we're looking at Form 310. There's an attending physician and a consulting physician and or licensed psychologist, that they have to confirm that the person lacks the capacity to make the decision. And this is basically, the reason for this protection is basically they're looking at the cause, nature, extent, and probable duration of the person's incapacity. If there's any possibility that this person may regain capacity, maybe they're just temporarily in a coma, if there's any chance that they may regain the capacity to make this decision, we aren't going to take that ability, that right to make this decision away from them. So that's the protection in that regard. There is also special criteria for evaluating capacity. One of the 2 evaluators must be employed by a developmental disability service office or employed for a minimum of 2 years in a facility operated, licensed, or authorized by OPWDD, or they must have been approved by the OPWDD commissioner. If anybody has physicians or licensed psychologists on their staff or in their Article 16 clinic that would like to be certified, or actually that they would actually meet that criteria now that I'm thinking of it. But if you know of anybody that is in any other agencies, if there's someone in the hospital and you're having difficulty locating someone to provide the capacity evaluation that meets this criteria, always feel free to give SDMC a call. We have some connections through OPWDD. We can also look up some contacts in our database, and we will do whatever we can to facilitate and expedite the process for you. The attending physician and concurring physician certification for end-of-life care is the 320AB form. This used to be 2 forms, and in response to some concerns that were expressed about the redundancy of the process, we worked with MHLS to come up with a streamlined version of the form. And so that's 320AB. And it basically, we require the attending and concurring physician to both concur that this person has either a terminal condition or permanent unconsciousness, or they will require life-sustaining treatment and their condition is irreversible and will continue indefinitely. Well,
That's all.
No.
Sorry.
that's okay. Stay tuned. That's it, yeah.
Bear with us for a second.
Okay. I'm going to actually just talk a little bit about the healthcare decisions making process and what we're going to be talking about too. So we talked about the medical condition. Sometimes people really struggle with how to, what is the terminal condition. If you're having difficulty with that, feel free to give us a call. I can talk to you about what we're really looking for on those forms, what type of information really qualifies. Sometimes the difficulty is also in determining the extraordinary burden, because in addition to meeting the medical criteria, the individual is also going to have to, the physicians are going to have to demonstrate that the individual also continuing the life-sustaining treatment would be a burden. So it might be that the expected outcome of the life-sustaining treatment, aside from the person's intellectual or developmental disability, the outcome is futile. So maybe keeping them on the ventilator is going to keep them alive. It's going to be successful in that. It's not going to solve the underlying problem that resulted in their condition in being placed on the ventilator. So that's really what we're looking at in terms of the burden of treatment. There's also sometimes we've had situations where the burden of treatment has been supported by the physicians explaining and the residential providers explaining that if the individual, after they've been on a ventilator for more than 2 weeks, the decision to, let's see, can you go to 50?
50.
Yeah.
Okay, we're just going to use this
Oh, okay.
view for whatever reason there's a technical problem. So.
Okay, we have a little technical problem, so the view is going to be a little bit different. So when we're looking at the burden of treatment, so we're really looking at, is the treatment painful? Is it futile? Is it without any benefit? Will it fail to improve their quality of life? So there are folks that maybe they're on a ventilator and they have to be restrained for the duration because they're trying to pull it out. We also have people that cannot tolerate a PEG tube and will repeatedly try to pull it out. So these are situations where we really have to consider the effect on this person's quality of life. We've also had situations where the panel, our volunteer panel, has made these decisions in terms of placement. Is if this person requires skilled nursing, a higher level of skilled nursing care than the residents where they've lived for the past 25 years. How is that going to impact their quality of life? They're going to be cared for by strangers in an unfamiliar environment. So these are all things that it's very important for providers to share with our panel members and during the hearing in terms of the impact on this person's best interest. Okay, so your testimony would be in terms of, would the pain and suffering outweigh the benefit of continuing the life-sustaining treatment? Would the treatment keep this person alive but merely prolong their suffering? And is it futile, any hope of recovery or restoration of function? Okay. So the artificial nutrition and hydration, because food and water is considered a basic human right, these are also going to be considered separately. So 2 physicians must also agree that there's no hope of maintaining life in terms of the artificial nutrition and hydration would be futile. It might keep them alive, but it's not going to cure them. The artificially provided nutrition and hydration itself could also pose an extraordinary burden. And this is in those situations where someone, maybe they have, their body is shutting down, they're actively dying, and overloading them with fluids and pumping food into the, in nutrition into their stomach is not necessarily going to be digested or absorbed. It's going to create discomfort. So that's what we're looking for with artificial nutrition and hydration. There's also a requirement that healthcare decisions will not be influenced by any presumption that an individual with an intellectual or developmental disability is not entitled to the full and equal rights, protection, respect, medical care, and dignity afforded to persons without intellectual or developmental disability or by any financial considerations. This is specifically in the law. It's also included in our Form 300 in the attestation that's submitted by the declarant. It should never, ever be a part of a hearing. There should never be any discussion as to how expensive it is to keep someone maintained on a ventilator or attached to the tubes for life-sustaining treatment. In the Healthcare Decisions Act, because of the risks, this is dangerous ethical territory. So there are special protections in the Healthcare Decisions Act statute, and we're looking at that this is not intended to permit suicide, assisted suicide, or euthanasia. And the guardian or the decision maker cannot consent to any act or omission that the patient could not consent to if the patient had the ability to make a decision. And all advocacy and healthcare decision making is solely and exclusively based on the best interests of the patient. Those are the decision making considerations. When we issue consent through SDMC, our decision is always issued in writing, and this is important to note because when you complete the MOLS checklist, which you're still required to do even with the SDMC process, you're going to want to make sure that you note that it was completed in writing and that the 380A is attached to the MOLS checklist. It's going to be signed by the panel chairperson. It's witnessed by the SDMC representative at the hearing with the date of the hearing. The consent remains valid for DNR, DNI, and any orders to withhold or withdraw life-sustaining treatment with no expiration date. So on the second page of the consent that's issued by SDMC, you're going to see that the legal criteria for that gives us the jurisdiction and the statute for making this decision, that as long as the attending physician agrees that this person meets the capacity requirements and the medical condition meets the requirements of the Healthcare Decisions Act, that the decision remains in effect. All interested parties receive a copy of this, and that includes the declarant, the residential provider, the executive director receives notification, any family members that are included as correspondents. The attending physician has the responsibility to notify the following people following the decision. So for SDMC, the decision is made at the hearing. The individual is notified. Typically, a copy of this decision is placed in the individual's record. Mental Hygiene Legal Services is notified, and they're actually there at the hearing. It's not unusual for them to come to the hearing with a letter of no objection that they will hand over to the attending physician after the hearing to indicate that they have no objection to the decision being implemented as soon as possible. OPWDD, for people through NYSARC, it would be your CEO of the residential provider. If it's someone that lives in the community, it's the regional OPWDD director or designee through the regional office. Through OPWDD, if they live in a state-operated facility, it's someone through the state operations office. And we have all of that contact information. At the SDMC hearing, we actually give a copy of this contact information to the attending physician following the hearing so that they have everything they need to complete the notifications in a timely manner. So the notifications, once the physician has documented in the record that the notifications have been completed, the treatment that was approved to be withheld, so that typically is the CPR and intubation, that can be implemented as soon as the notifications have been made. You don't have to wait the 48 hours, you just have to ensure and document that the notifications have been made. To withdraw treatment, and this is when someone is on a ventilator and the ventilator is going to be removed or extubated, the attending physician must wait at least 48 hours before withdrawing treatment to ensure that there's no objections, or as soon as they've been issued no objection by either the CEO, it depends on who received notification. We're looking at the CEO or the executive director of the agency, or it could be through OPWDD, the state office, or the regional office, depending on where the person's residential placement is. So the consent is valid for DNR, DNI, orders to withhold, withdraw life-sustaining treatment, and we've had the whole range of life-sustaining treatments. We've also had comfort measures. It could be, some of these consents are very unique and very individualized. All interested parties receive a copy, no expiration date. Again, there's no, it remains in effect as long as the person continues to qualify for the medical, meeting the capacity and medical condition. There are certain individuals that have the right to object, and it includes the patient. And if the patient objects to the decision, we would fully anticipate that providers would facilitate and assist the individual with the objection. Parent, sibling with whom the individual has substantial contact or resides, they can also object to the decision. The attending physician, which sounds confusing, but the attending physician can be any physician involved in the care and treatment of the individual. And this is basically a protection in the 1750B process that applies more so outside the SDMC process. This is to protect the individual in those instances where maybe the end of life care decision is being made by a family member with a physician, and maybe another physician involved in the care, maybe the hospital physician with the family member made this decision, and the attending physician outside the hospital feels that this person doesn't really meet the criteria, and they could object to that and ask for a review of the record. So it could also be any other healthcare practitioner, the agency executive director, MHLS, or anyone from OPWDD. The objection process, objections are typically issued in writing, but they could be orally. The decision to withhold or withdraw treatment is suspended until the objection is resolved. And the objecting party must notify the guardian, or in this case, SDMC, and any other parties identified in the Healthcare Decisions Act process. So anybody who received notification of the hearing should be receiving notification of the objection. A special proceeding can commence in a court of competent jurisdiction, and that's in the case of SDMC. If it's a case with a family member, there is something in 1750B that allows the family members to go to mediation. But they're looking for some type of resolution in a very timely manner under the circumstances. So I'm going to talk a little about the MOLST. I know we're almost out of time, but just bear with me. This is the legal requirements checklist for individuals with developmental disabilities. Any life-sustaining treatment decision to withhold or withdraw must have a copy of the legal requirements checklist for individuals with developmental disabilities attached. The MOLST, if the MOLST is going to be completed, it should be a best practice. It should be reviewed by a physician every 60 days to ensure that the person continues to meet that criteria, or that there's been no change. And there's certain conditions. If the person is transferred to the hospital, it should be reevaluated. And again, the MOLST checklist. And for SDMC purposes, also a copy of the decision should be attached to the MOLST. My recommendation would be to keep several copies and make sure that you have that available, because what I've heard from providers is that sometimes when they're hospitalized, they don't receive a copy or the actual pink form back. So I just encourage you to be proactive with that when you can. So as far as the MOLST and SDMC, there's some conditions that are a little bit more challenging when SDMC is the decision maker. And there's no option of a trial period on the MOLST. So a yes or a no must be communicated for each life-sustaining treatment that's specifically referenced on Form 320AB. Some decisions may be deferred, and it becomes a little bit of a problem with the newer process with the eMOLST. I'd be happy to come back and talk about this in more detail, but Comfort Care does not authorize any additional withdrawal or withholding of life-sustaining treatment that has not been specified on the SDMC decision. This is very important. We've had 3 objections from MHLS within the past year, and it's basically been because Comfort Care was included on the decision, but when the physician was completing the MOLST, Comfort Care was extended to include things like withholding fluids or things that weren't specifically agreed upon in the consent. So, and again, the MOLST is not required, but it is recommended. It is a best practice to have the MOLST. So the consent for end of life, I think we've talked about this. It remains in effect as long as the person continues to meet that qualifying condition. Comfort Care, go back up to, so Comfort Care is medical care and treatment that's really provided to reduce pain, to relieve pain and reduce suffering. Physicians can't really extend any additional life-sustaining treatment restrictions that are not specified on the SDMC decision. And finally, helpful tips. Always call us if you have any questions, even if it's not SDMC related. If we don't know the answer, we might have a contact through OPWDD or even through OMH if you have patients that, if anybody is listening to this recording that serves OMH, we are always available to help. If you need something to clarify, we sometimes have physicians that are unwilling to accept family members as that are not appointed legal guardians. We have been involved in intervening in those circumstances as well. We can also contact MHLS or communicate concerns to them to make them aware of certain situations. But check with the Justice Center webpage for the most recent forms. And if the case is expedited by the physician, please fax the case, and always, always call if you fax. If you have encryption, you can send it to the SDMC website. And be sure to send the supporting documentation with the declaration. That includes a copy of the annual physical, any recent labs, and any consults that are related to the request. So think of it in terms of what would you need to provide informed consent for somebody? What would you need to know about this individual in this circumstance? So, and also be prepared to provide testimony. If you are going to be going to an SDMC hearing and you've never been before, feel free to call us. I'd be happy to go through the process with you. I have a guidance document that I can share with you to give you a sense of the types of questions. And also knowing the case, I can tell you pretty much, if I look at the case, I can tell you pretty much the types of questions, and also where there might be some difficult questions from panel members. I have some list of resources. Again, I find the OPWDD Healthcare Choices booklet is a great resource, and I understand they are going to be coming out with another one about 17A guardians, so I'm looking forward to that one as well. And my contact information is here. And hopefully we will share this recording and also a copy of the PowerPoint. You'll have this information, but I thank you for your attention and your patience with the process. And if anybody has any questions, feel free to give me a call anytime.
We do have a couple of people with questions, but in the interest of time, since we're running over, I'd ask folks that didn't have the question answered to just email it to me or Josh, and we will forward that on to Laura. I wanted to thank you for the overview, and we'll be sending out the link to the recording and a copy of the slides, as I said earlier, in a week or two. Thanks, everyone.